Welcome back to the Constitutional Clarion. This video is about the constitutional validity of Section 18C of the Racial Discrimination Act. Now, as many of you will know, this has been for a long time quite a controversial provision. What it does is it makes unlawful certain statements, such as those that are effectively racial abuse. Some years ago, there were attempts to amend the provision, but there was quite a deal of controversy about how to do so and what the scope of the provision should be. The problem with Section 18C is that it sits at that very sensitive point where different rights conflict with each other. So on the one hand, you have the right to freedom of speech, and on the other hand, you have the right to live your life peacefully without being subject to racial abuse. The issue of the validity of Section 18C is likely to come before a court as a consequence of litigation commenced by one senator, Senator Faruqi, against another senator, Senator Hanson, over a tweet that Senator Hanson published on Twitter, or now called X. Senator Hanson, in response, has signalled that she will claim that Section 18C is constitutionally invalid. So what are the potential arguments that might arise? Well, there seem to me to be two potential constitutional arguments that could be run. The first is that there is no constitutional head of power for the Commonwealth Parliament to enact Section 18C. And the second argument is that Section 18C breaches the implied freedom of political communication. Now, I understand from what I've heard that it's actually only the second argument at the moment that's going to run, although you never know, they might pick up and run also with the first argument, which I think has some basis to it. Now, due to length, I'm going to cut this into two different videos. So we'll have the first video, this one, about the issue about whether there's a head of power to support the legislation, and the second video will deal with the implied freedom of political communication issue. I should mention that I set this issue as a constitutional assignment back in 2017, where students were asked to write a judgment on the constitutional validity of Section 18C, taking into account both the head of power argument and the implied freedom argument. Now, as I told my students then, this is not about the political issue, about whether you think there should be such a law, and whether it's right and proper that such statements should be punished. What I'm talking about here is the discrete legal question about whether the existing law is constitutionally valid. Now, this is a different matter altogether from arguments about political and moral matters. Now, the first thing that one needs to do when undertaking a legal analysis of this kind is to read the section quite carefully. So this is what it actually says. It is unlawful for a person to do an act otherwise than in private, so that means you have to do it publicly, if A, the act is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate another person or a group of people, and the act is done because of the race, colour, or national or ethnic origin of the other person, or of some or all of the people in the group. Now, that section also needs to be read in context with Section 18D. 18D says, Section 18C does not render unlawful anything said or done reasonably and in good faith in the course of any statement, publication, discussion, or debate made or held for any genuine academic, artistic, or scientific purpose, or for any other genuine purpose in the public interest. So that gives an excuse to people who might be expressing things for those genuine reasons and in good faith. Now, previously, in a case called Kuwata, the validity of the Racial Discrimination Act was upheld on the basis that it implemented the Convention on the Elimination of all forms of racial discrimination. Now that's abbreviated as CERD and known as CERD. So that's what I'm going to call it, CERD, C-E-R-D. Now on this basis, it fell within the external affairs power in section 5129 of the Constitution because the law was, and this is the somewhat garbled terminology that's used, but anyway, here's the test, reasonably capable of being considered as appropriate and adapted to implementing a treaty to which Australia is a party. However, Section 18C was inserted in the Racial Discrimination Act after that. So whether or not it actually implements the treaty provisions still needs to be assessed by a court. It's not been decided. Now there are two relevant treaties here. The first one is CERD, the one about racial discrimination, and the second is known as the ICCPR, that is the International Covenant on Civil and Political Rights. Now Article 20, Subarticle 2 of the ICCPR says this: any advocacy of national, racial or religious hatred that constitutes incitement to discrimination, hostility or violence shall be prohibited by law. Now note there that it refers to advocacy of racial hatred and that it must incite discrimination, hostility or violence. Now this is a much higher standard than simply saying that something offends or insults a person and is motivated by reason of that person's race. Article 19.2 of the ICCPR also confers a right of freedom of expression. And Article 19.3 provides that this right may be subject to certain restrictions as provided by law that are necessary for respect of the rights or reputations of others and for the protection of national security, public order or public health or morals. According to the United Nations Human Rights Committee, which is the body internationally that interprets this treaty, when implementing Article 22, parties are required to comply with Article 19.3. Now this gives rise to problems both for whether Section 18C actually implements Article 20 and also because if it does so, it's only a partial implementation of that article, and it may also be contrary to what is provided for in Article 19. The existence of these problems was recognised at the time that the Section 18C was enacted, so during the second reading debate. And at that time, the Shadow Minister, the Shadow Attorney General, Darryl Williams, said this: Article 22 of the ICCPR refers to advocacy of racial hatred where that constitutes incitement to hostility or violence. This is clearly much stronger language than that used by the bill. As a result, the bill goes much further in its prohibition than is provided for in the covenant. That's the covenant meaning the ICCPR. He goes on to say, the criminal offence, I might add this is now taken out of the legislation, but anyway, at the time there was a criminal offence in the bill. So he says the criminal offence of incitement to racial hatred and the civil offence, that's the 18C bit, the civil offence of offending a person by an act that was partly motivated by race fall short of the racial hatred constituting incitement to hostility or violence. Another consideration, he said, is that the covenant contains guarantees of freedom of expression. We must be careful not to lose sight of the objective of freedom of expression that is also enshrined in this covenant. All right, so that's what was said by the Shadow Attorney General at the time, recognising there are genuine problems about whether or not this provision, 18C, is implementing a treaty. Now, what about the other treaty, CERD? Well, Article 4A of CERD provides that parties shall declare an offence punishable by law all dissemination of ideas based on racial superiority or hatred, incitement to racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of persons of another colour or ethnic origin, and also the provision of any assistance to racist activities, including the financing thereof. Now, Article 4 is also subject to the caveat that persons must act with due regard to the principles embodied in the Universal Declaration of Human Rights, which of course includes freedom of speech, and the rights expressly set forth in Article 5 of this convention. Okay, and that includes the enjoyment of the right to freedom of expression and opinion. The standard set out in Article 4A appears to be higher than that in Section 18C. First of all, it's directed to criminal offences, unlike Section 18C, which contains a civil offence. As I said before, an earlier version of the bill did contain an offence, a criminal offence of incitement to racial hatred, which Darrell Williams referred to, but that was later removed from the bill due to concerns about the subjective nature of hatred. Second, Article 4 is directed at acts which incite racial discrimination or violence, not words that are likely to offend or insult or even humiliate, as in Section 18C. The United Nations Committee on the Elimination of Racial Discrimination, which interprets the Third Convention, did note in 2013 that the expression of insults, ridicule or slander should only be sanctioned as offences punishable by law where it clearly amounts to incitement to hatred or discrimination. And this is due to the need to balance these restrictions against the importance of maintaining freedom of expression. On this basis, Section 18C would not be regarded as implementing Article 4 of CERD. The United Nations Committee's approach is similar to that which has previously been taken by the High Court in a case called Coleman and Power, where the court read down a statutory provision concerning offensive and insulting language so that it only applied to offence that was directed at hurting identified persons and which was intended to provoke unlawful physical retaliation. When considering whether or not a statutory provision such as Section 18C implements a treaty, one must compare it against the terms of the treaty that are sufficiently specific to support it. Hence, one must compare the content of Section 18C against Article 4A of CERD and or Article 22 of the ICCPR. It's not enough to say that CERD is against racial discrimination and the Racial Discrimination Act is against racial discrimination. So the Racial Discrimination Act and all its provisions are therefore supported by the External Affairs power. Now, for anyone who's watched The Castle, the movie, that's really a Dennis Denuto type of argument about the vibe of the treaty, whereas the High Court has been far stricter in the past about treaty implementation. For example, in a case called Victoria and the Commonwealth, the High Court upheld the part of a statutory provision which required a person's employment not to be terminated without a valid reason, as this was consistent with Article 4 of the relevant ILO treaty. However, it struck down the additional legislative requirement that a person's termination not be harsh, unjust or unreasonable, because this went beyond the terms of the treaty. This was because it provided an additional ground of unlawful termination. As it was not supported by the treaty, it was therefore invalid because therefore the External Affairs power didn't support it. Now, on the same basis, it is at least arguable that the terms of Section 18C, being applied at a much lower level than those set out in Article 4, and providing for additional civil offences for acts that insult or offend, are beyond the scope of the treaty and therefore outside the support of the External Affairs power. There is, however, an authority to the contrary in a case called Tobin and Jones in 2003 from the Federal Court. There, the Federal Court accepted the Commonwealth's argument that acts done in public that offend or insult and are done because of a person's race are, quote, likely to incite other people to racial hatred or discrimination. But are they? If you direct a racial slur against a group of people from that racial background, it seems to me most unlikely that it will incite any of them to hate or discriminate against their own racial group. And if someone else hears your racial slur, it's just as likely, or probably even more likely, that they would be disgusted by your conduct and direct their hate at you rather than be incited to hate or discriminate against the racial group that you have just slurred. But even if incitement to racial hatred or discrimination was likely, is this enough? The UN committee said that these acts must clearly amount to incitement to hatred and discrimination before they could fall under Section 4A. And there's nothing in Section 18C which indicates that the offence or insult has to be such as would incite persons to hatred or discrimination on the basis of race. The Federal Court seemed to think that Section 18C gives effect to other provisions of CERD that are generally directed against racial discrimination. But many of those provisions are so vague that they're not sufficiently specific to direct the course to be taken by a party as required by the High Court in Victoria and the Commonwealth. Article 4, in contrast, in CERD, is specific, and Section 18C does not implement its terms. What would the High Court say? Well, as always, that's anyone's guess. Sometimes in the past, it has been very strict about giving effect to specific obligations in treaties, but other times it's been less so. It's very hard to pick where it will fall. But there are certainly genuine grounds for at least arguing this point. There's also an argument that the partial implementation of the relevant treaty provisions by Section 18C is inconsistent with the provisions in those treaties directed at protecting freedom of speech. This too may mean that the external affairs power cannot be relied on to support the validity of Section 18C. For example, Justice Kirby in Coleman and Power considered that a prohibition on insulting words goes beyond the permissible limitations on freedom of speech set out in Article 19.3 of the ICCPR. Section 18C is also directed at words which offend or insult, and therefore seems to go beyond the permissible limits on freedom of speech as set out in both the ICCPR and CERD. Okay, well, if the external affairs power doesn't apply, is there another head of power that would support it? What about the race power in Section 51(26) of the Constitution? Would that support Section 18C? The race power allows the Commonwealth Parliament to make laws with respect to the people of any race for whom it is deemed necessary to make special laws. A majority of the High Court held in the Kawata case that the Racial Discrimination Act was not supported by the race power because it's not a special law, because it applies to people of any race. In the Tasmanian Dam case, however, the High Court qualified that proposition by accepting that a law of general application could still be special if it is of particular importance to a racial group. So, for example, where protecting a cultural heritage site, which is of universal value but of particular significance to an Aboriginal group. In Western Australia and the Commonwealth, the majority said that a law may be special even when it confers a benefit generally, provided the benefit is of special significance or importance to the people of a particular race. Can it be said that Section 18C is of special significance in this way to a particular race? I think the answer is probably not, because it's significant to all races, as was the case in Kuwata. So, could Section 18C be held to be invalid for want of a constitutional power? Possibly yes, at least in relation to low-level matters where an act offends or insults. But it will depend upon whether the High Court takes a rigorous and strict approach or a more woolly one that is influenced by the vibe of the treaties rather than their specific terms. If the point is argued, we may find out, but at the moment it seems more likely that it's the implied freedom of political communication which is going to be the subject of the focus in the constitutional argument, assuming that the case goes on to run. Because of that, I will deal with that in a separate video. Thank you for watching the Constitutional Clarion, and I look forward to seeing you next time. Goodbye.